The Supreme Court has agreed to hear a case that could empower members of the House and Senate minority to compel the executive branch to turn over information to congressional investigators. The case, known as Carnahan v. Maloney, involves a lawsuit filed by Democratic lawmakers on the House Oversight Committee against the General Services Administration, GSA, for refusing to provide records related to the lease of the old post office building in Washington, D.C. that was awarded to a company owned by former President Donald Trump. The building was renovated and converted into a luxury hotel, the Trump International Hotel, which drew criticism and lawsuits for allegedly creating conflicts of interest and violating the Constitution's Emoluments Clause. Trump's company sold the hotel last year, and it was reopened as a Waldorf Astoria. The lawsuit stems from a 2017 request by the committee Democrats for unredacted lease documents and other information from the GSA under a federal law known as Section 2954, which directs executive agencies to turn over certain information to the congressional oversight committees. The law states that a request may be made by any 7 members of the House Oversight Committee, and is viewed as an oversight tool for members of the minority party. The GSA initially complied with the request, but later declined to provide more information, saying it would review it if 7 members of the committee sought the information. The committee Democrats then renewed their request, but the GSA did not respond. It did, however, turn over most of the records sought by the committee Democrats after announcing it would construe the requests as made under the Freedom of Information Act. The committee Democrats sued the GSA in federal district court, seeking a declaration that the agency violated Section 2954 and an order that the GSA hand over the records at issue. The district court dismissed the lawsuit, ruling that the committee Democrats lacked standing to sue because they did not have enough votes to issue a subpoena for the records. The court also held that Section 2954 does not create a right of action for individual members of Congress to sue executive agencies. The committee Democrats appealed to the U.S. Court of Appeals for the District of Columbia Circuit, which reversed the district court's decision in a 2-to-1 ruling. The appeals court held that Section 2954 creates a legally enforceable right for individual members of Congress to obtain information from executive agencies, and that the committee Democrats had standing to sue because they suffered an injury when they were denied access to information they were entitled to receive. The appeals court also rejected the GSA's argument that allowing such lawsuits would interfere with the separation of powers and create a flood of litigation. The Biden administration, which inherited the case from Trump, asked the Supreme Court to review the appeals court's ruling, arguing that it was wrong and dangerous. The administration contended that Section 2954 does not create a right of action for individual members of Congress to sue executive agencies, and that such lawsuits would undermine the constitutional balance between Congress and the executive branch. The administration also claimed that allowing such lawsuits would encourage individual members of Congress to bypass the normal legislative process and resort to litigation instead. The Supreme Court granted certiorari on May 15, 2023, meaning it will hear oral arguments in its next term, which begins in October. The case could have significant implications for congressional oversight and executive privilege, especially when there is divided government or partisan polarization. The case could also affect other pending lawsuits filed by individual members of Congress against executive agencies or officials on various issues.